Supplementary list, pronouncement of judgment.
With all these incongruities, lapses, and patent illegalities that have occurred in exercise assessment of the writ petitioner and the APAR by respondent corporation, this court need not go further to touch the other issues as raised as to whether the writ petitioner was subsequently promoted by Fetch DPC, or whether the same was done by way of review DPC. The glaring facts have emerged from the entire series of events will surely call for interference by this court and for appropriate directions to be issued to respondent corporation to undertake corrective measures. Without leading to the precedents in law both of the Honorable Supreme Court and of this court on this point, the position of law being well settled and this president allowed the following directions. 1. The respondent shall formally communicate the APR for the both periods assessment year 2015-16 to the petitioner within a period of 2 weeks of his order. The petitioner shall thereafter be allowed to represent against the same within a period of 4 weeks thereafter of formal receipt of APR. 3. The respondent on receipt of representation shall decide the same within 2 weeks thereafter. It is further directed that should entries be upgraded in consideration of the representation, also taking into account the petitioner's earlier APRs, the respondent authority shall constitute a review DPC for consideration of petitioner's promotion with effect from 1/1/2016 along with all consequential reliefs. It is also directed that before such exercise, a reasoned determination shall be undertaken by DPC as to which single rating for assessment year will be applied in the consideration of said promotion in accordance with Rule 6.4.3 of the Promotion Policy Rules in NIPCO. The entire exercise shall be completed in a period of 6 months from the date of receipt of the representation with petitioner. For the following reasons, as for above, which stands allowed to extend indicated.
Is it common judgment, Lordship?
Yes?
There were 2 cases.
Yes, I'm going to pass the next one. Guarantee. Yes. The incident petition is essentially substantially continuation of WPC number so and so between the same parties, which has been disposed by this court. The grievance with regard to the decision dated 8/4/2017 adopted by Respondent Corporation by the Board of Directors in the 29th board meeting, whereby the petitioner was extended financial benefits only from the date of joining the promotional post on 21/4/2017, not from the date of promotion as 1/7/2016. In view of the decision of this court rendered in WPC number 50, where the writ petition has been partly allowed, the instant writ petition in view of the directions contained therein need not be adjudicated any further, as the outcome of the exercise will determine the pre-ambient instant application also. According to the applicant stands disposed of. Yes.
May it pleases your Lordship. Lordship, item 29, in fact, that is was already disposed of, your Lordship.
29?
Yes, your Lordship.
It's already died.
Lordship.
Second burial. Wrongly listed.
How lie, your Lordship?
Your Lordship, I beg to mention item 24, Your Lordship.
20?
24, Your Lordship.
24.
Conducting counsel is out of station, Your Lordship.
Who is the counsel on the station?
Mr. Philomonongri, Your Lordship.
The man, look, is
4 weeks then.
4 weeks, yes.
How lie, your Lordship?
As the counsel for the petition out of station list. Yes. That's it.
Please, Your Lordship, I beg to mention item number 33.
33.
In this matter, we just received the rejoinder affidavit, so we need some more time, Lordship, to seek instruction from the client.
Who's for the petitioner? Have you? Who's for the petitioner?
I'm on behalf of the
You
petitioner.
have no objection?
No, Your Lordship.
Yes, 4 weeks. Yes.
Much obliged.
Without 4 weeks. And the request of the so and so for the respondent. Yes.
May it please, Your Lordship, I beg to mention item number 27.
20?
27.
37?
27, Your Lordship.
27, yes.
Your Lordship, the conducting counsel is out of station.
Who is the conducting counsel here?
Mr. KCH Gautam.
No objection.
4 weeks, huh? No objection, no? Yes.
Obliged, Your Lordship.
It's a joint request.
26.
Who's for the petitioner?
Petitioner. I am, your Lordship.
Who's the senior? Mr. Nair?
Yes, your Lordship.
4 weeks, yes.
Much obliged.
Yes. Yes.
I beg to mention item 18 of today's daily.
18.
18, my lord. My lord, the moot issue which is to be decided in this petition has already been decided by the Manipur High Court. But however, the government has assailed that judgment in a writ appeal, and that writ appeal is still pending, my lord.
4 weeks.
My lord, my lord, the interim order may continue.
There's an interim order. Interim order should continue next week. Yes.
Much obliged.
May please lodge. Lordship, I beg to mention item number 70, Lordship.
Number?
17.
17.
Yes, Lordship.
Who's for the other side?
I am the petitioner, my lord. They were raising one objections, my lord, whether we were a registered society or not. I have a copy of the registered society, my lord. Because at 2000.
So why are you taking time today for on what ground?
Lordship, my apologies, but the brief is with the senior government advocate, Lordship. And
the brief?
Lordship.
Who's the senior government advocate who's holding the brief?
Mr. S.N.
He's not here today?
No, Lordship. Let it come in.
Then you file it by way of affidavit,
my lord, and let it come in the middle of June, my lord. If subject to my lord's convenience.
3 weeks, okay.
My lord, my lord.
Okay, if possible, yes.
Much obliged.
Lordship, I beg to mention item number 20 and 21, Lordship. 20 and 21. Let it come after 2 weeks, Lordship.
20 and 21?
Yes.
Item number 21, I'm for the petitioner.
On?
Item number 21.
You have no objection? 2021, 4 weeks, yes. Yes.
Right.
That's it.
Supplementary list, item number 2.
Net results. When I will come to page.
One second, let the file come first. Before I come to your page.
Well, page 22, annexure 6. Malad, he retired on 31/10/2022.
Page 22?
Yes, Malad.
He retired on?
31/10/2022. Okay. And he filed a representation, Malad, letter, Malad, annexure 7, next page, for he sent his area pay statement by page 23. Then page 24, my lord, this...
his area amount is 65 lakhs?
Yes.
How is that possible, Mr.?
It is for...
he paid the wrong scale for his career?
It's for 10 years, my
What,
lord.
does any other similar... who is he? He's working as what? What is he?
Principal, my lord.
Principal of?
Polytechnic.
Okay.
My lord. Then this letter, my lord, was returned to the petitioner, annexure 8, my lord, next page. It was returned, my lord, with a request to resubmit after getting the non-withdrawal certificate from Treasury Officer.
Non-withdrawal means that you have not drawn the amount.
Yes. So next, my lord, page 25, my lord.
Yes.
This is also a letter to resubmit the statement.
Yes.
Then, my lord, annexure 26, my lord.
Annexure 26?
Sorry, my lord, page 26.
Okay.
Annexure 10. This letter was submitted, my lord, to the respondent number 3 for issuing the non-withdrawal certificate. And that
number 3 is the Treasury Officer.
My lord, Tura.
Yes.
So this letter is pending, my lord. And then
what is the problem? Why you have to come to court for this clerical kind of thing?
No, my lord, he has submitted this letter, my lord, to
when was this submitted? 21st of March 2023. So now, why you have already in the court
my lord, before that also he has submitted on annexure October 22 also. It was submitted, annexure 7.
Oh, you just come against inaction of the Treasury Officer.
My lord.
So mandable to issue Treasury Officer from the court.
Just to issue the
Yes, so appearing for the respondents.
My lord, I'm appearing for respondent number 1, 2 and 3, the state respondents.
You're a government advocate also?
Yes, ma'am.
Yes.
My lord, my humble submission that this representation is very recent. It's 21st March. So the Treasury officer may be directed to dispose of the representation within a specific time period. And plus, since the arrear pay is for the period of 2010 to 22, the Treasury officer will also take some time to verify from the records whether the amount has been withdrawn by the petitioner or not.
Why was this pay? Why was this anomaly? What did the arrears accumulate for 10 years?
Anomaly because of the government, my lord. Because earlier pay scale was 9,000, and suddenly they reduced. Then ultimately on 28, my lord, the government rectified the anomaly.
In 28 meaning?
My lord,
Let us see before we pass directions. Let us see this. From where does your right stem from?
But I come to.
Other similarly situated principals have been paid also. Have drawn their arrear amounts. Where is that? Just show that.
No, that letter is not here, but here annexure. There is one letter, my lord. Annexure 4, my lord.
Annexure 4. Yes. Allowed pension extension all India. Okay, AICTE.
Pay scale was given. Therefore, afterward it was rectified by the government, and AGS issued the final pay slip, my lord. So we have submitted the.
You retired in 2022. So till retired, you are not drawing the higher scale.
No, because of this non-withdrawal certificate, I am not in a position to submit, my lord. That is required.
Anything to say, Mr. Karmapang?
Lordship, I have no specific instruction.
Anyway, we'll dispose it of then, if it seems so. Of course,
yes.
The petitioner is before this court with a prayer that the respondent number 3 issue the non-withdrawal certificate for the period 1/3/2012 to 39/2022 in connection with the arrear pays due and payable to the petitioner. And for Mr. K. Sunal and his counsel for the petitioner submits that the petitioner has been compelled to come before this court in view of the fact that even though, since when? Last year?
Last year.
Even though, where's that?
October 2022 he retired.
Well, when did you give your first representation?
My lord?
When did you give your first representation?
First representation, my lord, on March. First is Annexure 7, my lord. It was on 31st October 22.
My lord, if I may point out one aspect. My learned senior is saying that Annexure 7 is the first representation.
No,
this letter was sent by the petitioner himself when he was holding the post of principal.
No, on the day I did.
On the date of retirement, he has sent it.
No, well and good. Yes, so Thamno.
Now we are in Annexure 10.
Even though prior to his retirement and thereafter, requests had been made, which, however, has not yet been acted up, which has not been acceded to by the, which has not been acted upon by respondent number 3. Stop. This is limited prayers that direction is issued to number 3 to initiate necessary action for release of the said non-withdrawal certificate. Stop. Therefore, MSP Agarwal, who's present on behalf of respondent 123, submits that the representation has been submitted only on 21st of March 2023, and such it is but natural that some time will be taken by respondent number 3 to process the same. Stop. Should we note your presence? Yes, Kermoplang is present on behalf of the respondent number 5. Stop. So, next paragraph. Looking to the limited prayer made by the petitioner, and in view of the fact that the entitlements as to only for the direction to issue respond number 3, this petition dispose with direction that the respond number 3 shall dispose of representation of the petitioner most expeditiously, preferred with a period of 1 month.
My lord, at least 3 months, my lord.
3 months? Okay, 2 months.
2 months. 2 months.
From the date of, when the date a copy of the order is presented before the said respondent.
Highly.
Item number 3.
Madonna. Pension.
I'm appearing on behalf of Mr. S. Sen, Your Lordship. These are MTC matters and Mr. Sen is on sanctioned leave. So I pray that the matters may come up after a week, Your Lordship.
Take instructions.
Yes, Your Lordship.
Yes, what's the name?
B. Kasano.
B. Kasano. There's a second Kasano. There's another Kasano.
Yes.
I heard MS B. Kasano, the counsel of the petitioner. Issue notice. MS is an non-country Vice President SN is present except as a respondent. Stop. Council of obtain instructions within government instruction within a period of 4 weeks from today. It is after 4 weeks. Yes, on so and so.
3, 4, and 5 are connected matters, Your Lordship.
Item number 6.
Who's that? Oh yes, Mr. Kurishi, you've seen the.
Yes, sir. Lordship, I've seen the letters given by the government.
So what remains now?
No, remains.
Any other incidental? You can come again.
Yes. Yes. Pursuant to these letters, in case we dispose of.
Yes. Mr. M.F. Kurushi fairly submits that pursuant to the letter dated 4th April 2023 that produced by the Advocate General, wherein a formula has been worked out for release of pending arrear salaries of SSA teachers, the matter may be disposed of.
Yes. The letter number and all those things.
It's okay, yes. Letter number so and so, producer so and so, yes. Accordingly, on the submissions, matters can be closed and disposed of. Fresh cause of action, you're free to come.
Yes.
Main list, item number 1.
Evidence, Lordship. This matter, my Lord, the last occasion also, Lordship has given us time for filing rejoinder. We are unable to receive the complete instructions. If Lordship give
then
2 weeks
close
time.
the rejoinder.
My Lord, only 2 weeks time we will be filing, my Lord. We are in the process of preparation. It's a bit lengthy matter and
Your Lordship,
litigation.
Yes, Mr. Paske, what do you have to say? Yes.
Your Lordship, I appear for respondent number 12 here. I have not received a copy of the affidavit filed by the state.
Where's the state? Mr. H.S. Changriso submitted that due to. What are the reasons you've given?
Unable to receive the complete instructions, madam.
Due to the inability to. Mr. Counsel also submits that due to the non-receipt of complete instructions from the petitioner, the rejoinder affidavit could not be filed as allowed by this court. He prays that he may be allowed 2 weeks' time to file the same. Mr. Paske for respondent number. Respondent number 12.
12, Your Lordship.
Has also made a submission that the affidavit filed with the state has not, a copy of the affidavit filed with the state has not been given to him. In his view, the matter is a matter after 4 weeks. The writ petitioners allowed further time to file the rejoinder affidavit and copies of affidavit to be exchanged between the concerned parties. If there anything, you just exchange it. You don't need order of the court. List accordingly and so and so. Yes.
Much appreciated.
Item number 2.
May it please, Your Lordship.
Yes, Mr. Cloud.
Your Lordship, this matter, Your Lordship, if it can be taken up on the next day, Your Lordship. Actually, Your Lordship, we've given the file to the Office of KGDC, Your Lordship, but apparently they've misplaced it somewhere, Your Lordship. So we haven't received the files back from the office.
Who's misplaced the file? You have misplaced the file?
Your Lordship, we sent it to the Office of KGDC, Your Lordship, and they've misplaced the file, Lordship. Your Lordship, if we can request the petitioners to give us the copies again, Your Lordship.
What to do, Mr. Chandra?
Well, I can provide him, but it's a delay method. Anyway, I can provide it to my friend.
Mr. Secretary, we are appealing for which respondent?
6, 7, and 8.
6, 7, 8. Secretary Rangsi, then Mr. Okay. MSc Nongklau, please the matter be adjourned as the copy which had been served upon the District Council has stated have been misplaced. Stop. Well, this is matter after 4 weeks. Petitioner has kindly will supply a extra copy of the petition to the respondent council.
Much obliged, Your Lordship.
4. Item number 4.
Please, Lordship.
Yes, Mr. Sangma.
Actually, the JHD is supposed to file one small affidavit, Your Lordship. This is just to refresh Your Lordship. This is the case where the private respondent have abandoned the case since from 2007, and then suddenly in the year of 2000, in the court of EM and the CM, and
where's your
Filing by way of adequate to bring on record the misapplication filed by the respondent.
Yes, when are you going to file it?
We file course of the day because we have sent for signature. We haven't received it.
It's just an application that they are claiming that they have filed the application before the.
That's the most important thing in your
Lordship,
case,
yes.
Mr. Sangma.
Yes, Lordship.
See whether they file a condemnation application
Yes,
as allowed by this court. If they didn't file, it ends there.
Lordship, let him file. But my case is here. Lordship.
What's your case?
Last time I have make a.
You don't want to give them the chance to file that.
Lordship, that
to
is
file that to show that to the court.
not
It's from the records.
No, I'm allowing, Lordship.
Then, because you're allowing, that means.
But only my
service submits that the application in the misappeal, file the response for CM will be filed in the course of the praise allowed some more time to file the Ms. S. Marapana, Learned Counsel for Respondents 1, 2, and 3, praise that they be allowed 1 week's further time to bring and record the application of the business appeal filed by the respondents before the CEM. Stop. Praise allowed this one so and so.
Hello,
5. Item number 5.
Yes, Mr. Jha.
My lord, they have rectified their mistake, my lord.
Have you? So now you're happy? You filed rejoinder?
Yes, my lord.
Put for hearing?
No, my lord. Rejoinder is required, my lord. My lord, here it is a case that they have taken a stand that I am not registered with the nursing. My lord, I say myself that if I am a government employee, can I advocate, my lord? Can I register as a practitioner before the bar? I cannot.
But that case is there, Mr. Jha. The other cases are there where you're not registered, you're not a registered nursing practitioner. You won't be entitled to that nursing allowance.
My lord, that whether that government employee can be registered.
Oh, you're questioning that now?
Yes, my lord.
So you're saying that the onus is on them?
Yes, my lord.
That
if
the
they
fact
will allow,
that you're not registered is not your fault.
My lord, I'm military. They have given me a training. I will bring on record.
No, we understand. You've been given training, but you're not registered with the nursing council. That's all.
My lord, they should have allowed me to register.
No, but you didn't have the qualification.
Qualification I have, my lord. I will place that, my lord.
Okay, then yes, Mr. Arja, praise funds allowed 3 weeks time to file the rejoinder of the affidavit filed by the officeman indicates that the defect has since been corrected. Stop. Next para, Mr. Arja, praise funds allowed 2 weeks time to file the rejoinder to the said affidavit. This thereafter and so and so.
Item number 6.
May I please, Your Lordship, let this matter come after 2 weeks as Mr. SD is on sanction leave.
What's the matter about? Can be disposed of?
No.
You're for the petitioner?
Yes, Lordship.
You're interested in the case?
Yeah, that is after 2 weeks, Your Lordship.
The list after 4 weeks and the request of the counsel for the petitioner is
7.
Yes, what is the development here?
May I please, Your Lordship? Lordship, on the last date, Your Lordship allowed
Number 7?
State
Yes, have they appeared? Who's paying for the state? Who's paying for the state here? No, 5 and 6, yes. So last time because submissions have been made. Steps not taken.
Yes, Your Lordship.
But office note indicates steps not been taken by the council for service of notice on newly implemented respondents for 7.
I'll just have to follow up with the local council. Your Lordship.
Office note indicates that steps by the petitioners have been taken upon the newly implemented respondent number 7 stop. Office to verify and petitioner, if the same is correct, to take steps immediately within 3 days.
I apologize, Your Lordship. I'll get done as well.
Take steps.
A.
The respondents are.
So you want to close this one?
They are supposed to place the
Your
records.
Lordship, Mr. SN is on sanctioned leave. I pray that the matter come up.
He's gone for vacation.
I'm not aware, Your Lordship.
This matter is supposed to be closed today.
My lord.
Right?
No, my lord. There is a direction to place the records of the meeting, my lord. That is order dated 19/4/2023.
MSZ inaugurally submits that the counsel for the respondents number 1 and 2 is sanctioned leave. He pays matter be taken up after 2 weeks.
Right, Your Lordship.
Only this matter of so and so.
9.
Lordship, I have received Paravest and I have already drafted. I may be just given 2 weeks time to file my counter, Your Lordship.
You're for 5 to 7. Respondents pray for allowed further 3 weeks time to file affidavits. Just thereafter and so and so.
10. 10.
5 to 6.
You're also,
Yes.
they're also praying for time for filing affidavit.
Of 1 to 4 and 5 and 6 you are appearing. Respondents pray for allowed further 3 weeks time to file affidavits. Just thereafter and so and so.
11.
I appear on behalf of the respondent, my lord, praying for some time to file my affidavit, my lord, in response to the contempt proceeding.
Should we ask for personal appearance? If no affidavit is filed, then we'll have to ask the contemptor, alleged contemptor, to come and stand here every date.
We'll file it.
And Mr. Thapa prays that he will allow further 2 weeks time to file the affidavit. Prays allowed after 2 weeks. Yes.
12.
Please, my lord.
Yes, Mr.
These
Sharma.
respondents are yet to file the affidavits, my lord. I have received Paravest and Your Lordship. I may be given 2 weeks time to file.
When did you receive Parav's comments?
Since last 3 weeks back, I was out of station for some time.
What's the matter about?
My lord, here I am challenging the impugned letters issued by the respondent number 2 and the respondent number 4.
Regarding?
My lord, whereas complaint has been made against me that I have misused some scheme pertaining to some PMA.
Misusing of some scheme?
My lord.
And let him file affidavit. Mr. Abraham, that GA pays one out for 2 weeks time to file affidavit. You file.
13. 13.
Yes, Mr. Pathak.
May I be lordship?
Yes. Yes. Oh, yeah, you're there.
My lord, in this case, my lord, affidavit has not yet filed, but this is the covered case, my lord.
What ECR?
The issue has already been settled. Yes, my lord. Non-communication of ACR. Yes, my lord.
Where Dr. Mozika?
Your Lordship, some next before the petition.
Will you suppose this matter of? Heard Mr. V. Kumar and MS from Thau advise Dr. Mozika for the party stop. The matter is clearly covered by the judgment of this court and so on. So we'll pass orders. Yes.
My lord. Give me your lordship.
14.
Raju order for non-communication of ECR. So,
Your Lordship, we are the respondents yet to file the affidavit, Lordship.
where are the respondents?
I did not hear, Lordship.
It's P. Barachaji, correct?
Yes, sir. This is Lordship.
Mr. V. Kumar is present on behalf of the petitioner. None appears on behalf of the respondents. Office note indicates that the affidavit is yet to be filed by the sole respondent. Stop.
Your Lordship, interim order shall continue.
In consideration, in interest of justice, further 2 weeks' time granted for affidavit. Interim order passed earlier shall continue the next days.
15.
Receipt, I need some time. Let it come after 2 weeks. You receive.
What last time you said that is not maintainable. You said today you satisfy the court that is not maintainable and that matter should be dismissed in limine. So satisfy the court now. 2 minutes enough.
This one, I asked information from the department one for this notification. So just for
You see, simple thing, Mr. Devnath. Just show you say that you should approach CAT. That's all, right? And CAT, the CAT CAT bench is available in Guwahati. Correct. So what else you want to say? Show me that this is which department?
NEPA here.
NEPA, yes. NEPA comes that you have to go to CAT.
the Ministry of Home Affairs. So
Exactly. Small thing like that also. Anyway, Mr. Devnath prays for the allowed further 1 week's time. 3 days time. 1 week's time to produce the necessary instructions.
Supplementary list for hearing, item 7.
What are we having concern?
Lordship, my senior is coming, Your Lordship.
No problem. This is Shulai's turn.
I'll just inform him. So.
Yes.
May it please your Lordship.
How to convert it?
May I begin?
Yes.
Lordship, my first contention is that number one is that the petitioner do not hold the sanction post, Your Lordship. That fact is reflected, Your Lordship, is in that has been replied in para 6 of the affidavit filed by the state.
1 second, Mr. Shulai.
Lordship.
Your first point is?
They do not, petitioner, they do not hold the sanction post, Your Lordship. That
The
fact,
petitioners were not appointed against vacant sanction post. What's the point you say?
Yes. Lordship, yes.
Not holding sanction post. He is not appointed
To the sanction post, Your Lordship.
against vacant sanction post.
Lordship, yes.
Okay.
Lordship, because that that fact, Your Lordship, is supported by the statement made in para 6 of the affidavit, Your Lordship. That has already been referred to, and also, Your Lordship,
1 second.
Lordship.
Let us see. Para 6.
Para 6, Your Lordship. Lordship, it says like this, Your Lordship, if Lordship kindly allow me to read,
Yes.
Your Lordship, that with regard to the amendment made in para number 2.2 of the writ petition, the answering respondent state that with the appointment of the various officials in different departments, the requirement of grade 4 staff to be attached to this office of various functionaries also equally arose. The requirement of these grade 4 staff was initially about, however, since there was a restriction in creation of regular posts, Your Lordship, can you see, Your Lordship?
That is what you have to satisfy this court.
Yes.
See, see, Mr. Shulai.
Lordship.
The thing is that if we are governed, if we're governed by certain method of recruitment, nowhere you can go divorce the rules and make some sort of independent kind of recruitment.
That
you
I'm
have
coming,
to
Your
satisfy
Lordship.
this.
That I'm coming, Your Lordship.
Yes.
That this recruitment, Your Lordship, is not according to the rules, Your Lordship.
Yes.
That would be my contention, Your Lordship.
Yes.
Lordship, can you see? However, since there was a restriction in creation of regular posts, as such, in order to ensure smooth functioning of the offices, the department proposed the requirement to be met through casual or contractual appointment purely on a daily wage basis, and in pursuance to that to which the advertisement dated 1/2012, Your Lordship. So, because there is a ban, Your Lordship, that is why, Your Lordship, the state government, Your Lordship, resorted to casual appointment, Your Lordship, by the advertisement dated 2012. Lordship, kindly come to the advertisement. Once again, Your Lordship, please kindly come to the advertisement. Lordship will, that advertisement is at page 29, Your Lordship.
Yes.
Lordship will kindly see that the advertisement says that applications are invited from the citizen of India as defined in Article 5(2)(a) of the Constitution for temporary engagement as peon in Meghalaya's Civil Secretariat, Shillong, on payment of daily wages, Your Lordship. So the advertisement is very clear, Your Lordship. It's very clear, Your Lordship, that they will be paid on daily basis, Your Lordship.
Yes.
Lordship, they took part in this selection process, Your Lordship. They knew fully well, Your Lordship, the criteria, the condition of service in the advertisement, Your Lordship. At this point of time, Your Lordship, my humble and respectful submission, Your Lordship, they cannot make a U-turn, Your Lordship, because an argument has been canvassed, Your Lordship, that since there is a rule of 1986, the recruitment should be done as per the rule, Your Lordship. So they cannot make a U-turn now, Your Lordship. In my humble and respectful submission, Your Lordship, the principle of waiver, the principle of estoppel will be applicable to the petitioners, Your Lordship.
Yes.
Lordship, this kind of appointment, Your Lordship, be it temporary or casual, Your Lordship, these are public employment, Your Lordship. So, Your Lordship, in my humble and respectful submission, Your Lordship, Article 14 and 16 of the Constitution will have to be applied, Your Lordship, because it has to be thrown open.
It's open. Why is it closed? It says from the citizens of India, so it's open to the entire citizens of India, yes.
This is open, Your Lordship.
So there's no violation of 14, 16?
Yes, that argument also that they cannot do that. This is casual recruitment is permissible, Your Lordship. That I'll put Umadevi judgment.
No. See, you come step by step. Okay. You see, you understand the arguments of the Senior Counsel. Mr. Gentle has said that now these appointments were made in the Secretariat Administrative Department in the Secretariat, correct? And then in matters of recruitment for inside the Secretariat Administrative Department, rules have been provided.
Yes, Your Lordship.
Now these rules were provided, so there stands that at that point of time, notwithstanding any kind of adjustment, they went through a selection process, they were appointed, they were vacant sanction posts, and subsequently advertisement was issued. So now it only stands to reason that since they're already there, why you want to regularize them, accommodate them against those posts?
Lordship,
no, that's what I'm saying. That you have to, those are things you have to answer.
Lordship,
step by step.
Because as I have submitted, Lordship, they are governed by the terms and the terms.
Correct. That's the first point. Yes, of course.
They cannot go beyond the advertisement. They cannot go beyond the advertisement, Your Lordship.
Yes.
They cannot go beyond the advertisement, Your Lordship.
Okay.
They are the beneficiaries of the advertisement of 2012, Your Lordship, and in that view, Your Lordship, they cannot make a U-turn as I have submitted, Your Lordship. They cannot canvass, Your Lordship, that the recruitment should be done as per the rule of 1986, Your Lordship. That rule I'll refer, Your Lordship, why we have not done so. Lordship, kindly come to the, where is that? To the supplement, to the regional affidavit, Your Lordship. I'll take, Lordship, straight away to the condition of eligibility at page 25.
From the rules.
Yes, Your Lordship. Why I submit, Your Lordship, that because the advertisement, the recruitment was not as per this rule. Kindly come to clause 16, Your Lordship, at page 25. Condition of eligibility, whether Your Lordship is with me.
Yes.
Lordship, kindly see B, 16B, Your Lordship. Age must have attained the age of 18 years and not attained the age of 27 years on the first day of the year in which the interview is held. Then, Lordship, kindly come back to the advertisement. Yeah. Advertisement say that a candidate should not be less than 18 years as on 1/3/2012. Then, Lordship, if you go by this, if you apply by this, Your Lordship, if Lordship kindly come to the writ petition at page 11, the petitioner number 1, she will be out, Your Lordship. Because she will not fulfill the criteria, the criteria of age as laid down in clause 16.
Respondent number 1. Where do you see that from there?
Lordship, kindly come to page 11 at paragraph 2.4, Your Lordship. Date of birth. Kindly see, Your Lordship.
So you mean that at that point of time, casual employment was made, there's only the minimum age was provided. No, not
above 18 years, Your Lordship.
Oh, that's why, born when?
That is why there is no
78. So why?
78, Your Lordship. If 2000, as of 2012, she was 30. She was 30 years.
Yes.
So that's why, Your Lordship. That's why, Your Lordship. This is a temporary engagement on daily wage basis, Your Lordship.
Yes.
Then another contention, Your Lordship, is that since they are holding a regular post, Your Lordship, which we strongly deny, Your Lordship, they should be given the equal pay and equal work, Your Lordship. In fact, Your Lordship, in my humble and respectful submission, Your Lordship, with regard to equal pay of equal work, there is no foundational pleading, Your Lordship, in the writ petition, Your Lordship, because the burden of proof lies heavily on them, Your Lordship. What is their nature of work, Your Lordship? And the mode of recruitment also is not a regular, is not for a regular appointment, Your Lordship. They should have laid the foundation, Your Lordship.
In the petition, nothing is there.
There is nothing, Your Lordship.
There's no averment also.
No, Your Lordship. This, Your Lordship, this averment has been made only, Your Lordship, after the state filed the affidavit, and then they filed the rejoinder affidavit, then they took this pleading, Your Lordship.
Okay.
So, in my humble and respectful submission, Your Lordship, they do, in view of the fact that they are not the holder of a sanctioned post, Your Lordship, they are a mere daily wage earner, Your Lordship, then they have no right to claim for the principle of equal pay for equal work, Your Lordship. That would be my submission, Your Lordship. I would like to, Lordship, to refer.
That is all. Finished.
Lordship, yes. Lordship, kindly.
Very good. Huh?
Lordship, I would refer to the case cited by them yesterday, Your Lordship. That is 1979. 1979 4.
On the point of?
On the point of regularization, Your Lordship.
1994?
The same yesterday you have cited.
Okay, okay.
1979 4 SCC 507.
That is Nagarajan.
Yes, Your Lordship. Your Lordship, kindly see paragraph 23 to 25.
Same paragraphs?
Yes, Your Lordship.
Yes.
Lordship, yes. Paragraph 25, Your Lordship, since there no regularization, in view of the fact that...
Sorry.
Lordship.
Code is not as fast as you. Yes.
Lordship, kindly see paragraph 25.
Yes.
Apart from repealing the condition that regularization connotes permanence, this observation furnishes the second reason for rejection of the argument advanced on behalf of the promoters, that the reason is that when rule framed under Article of India are enforced, no regularization is possible in the exercise of the executive power of the government under so and so in contravention of the rule. The regularization order was made after the provision rule. The seniority so were broken and could not therefore directed something which would do violence to any of the provision thereof. Regularization, in the present case, if men permanents operate from so and so, would have the effect of giving seniority to promotee over the direct recruitment, who in the absence of such a regularization would rank senior because of the seniority rules with the probation in consequence also confer on their on the promotees a right of priority in the matter of sharing the quota under recruitment rule. In other words, the regularization order in calling the appointment of the promotee as so-and-so with permanent would run counter the rule framed under Article 309 of the Constitution of India. What could not be done under the three set of rules as they stood would thus be achieved by the executive sphere. As such, goes is not permissible because an act done in exercise of the executive power of the government, as already stated, cannot override the rule framed under Article 309, Your Lordship. Lordship, for this I would like to...
Then that means you're going against your own rules by to put them under the RCW.
Lordship, my contention is...
So your just if I understand correctly, just Mr. Chulai, your contention is that this recruitment of the petitioners is totally divorced from the recruitment process that is prescribed by the rules. And so since it stands on independent footing, there is the government has at liberty to regulate it any way they want.
Yes, Your Lordship. That my solution. Then Lordship, kindly come to Umar Devi judgment, Your Lordship. That is 2006.
4 volume 1.
Lordship, kindly come to paragraph
page 1, yes.
12, Your Lordship.
Paragraph 12.
12, Your Lordship.
Yes.
Paragraph 12, Your Lordship. May I read it, Your Lordship?
1 second. Let me just... Paragraph 12. Right. Yes.
May I read it, Your Lordship? In spite of the scheme, there may be a question when the sovereign state or its instrumentalities will have to employ a person in posts which are temporary on daily wages as additional hand or taking them in without following the required procedure to discharge the duties in respect of the posts that are sanctioned and are required to be filled in terms of the relevant procedure established by the Constitution or for work in temporary posts or projects that are not needed permanently. This right of the union or of the state government cannot but recognize, and there is nothing in the Constitution which prohibits such engaging of person temporarily or on daily wages to meet the needs of the situation. So this kind of appointment, Your Lordship, is permissible, Your Lordship. Nor can
you see, the thing is that now the only difference I should understand is that they came to a process selection. Okay,
they went through by the selection.
That is what. So if you haven't come to a process selection, suppose you just appoint daily wages. Suppose you pick up 1, 2, 3, 4, 5, come as daily wage earners. Those people, then consideration of them for absorption, regular appointment is something else.
It is true. It is true. There is no denial, Your Lordship.
They went through a selection process.
They came by a selection process, Your
Correct.
Lordship. They came by a selection process. But can you see, Your Lordship, the mode of recruitment, Your Lordship?
So we understand that.
The mode of recruitment is on temporary engagement and on daily wage basis, Your Lordship. So it is permissible, Your Lordship. Then, Lordship, can you come to page 43 of that same judgment?
Page 43.
Para 43, Your Lordship. Para 43, sir.
Para 43 or page 43?
Para 43, Your Lordship. Lordship is with me. Para 43, Your Lordship.
Yes.
May I read it, Your Lordship? Thus, it is clear that adherence to the rule of equality in public employment is a basic feature of our Constitution, and since the rule of law is the core of the Constitution, a court would certainly be disabled from passing an order upholding a violation of Article 14 or in ordering the overlooking of the need to comply with the requirement of Article 14 and 16 Constitution. Therefore, consistent with the scheme for public employment, this court, while laying down the law, has necessarily to hold that unless the appointment is in terms of the relevant rules and after proper competition among qualified persons, the same would not confer any right on the appointee. So, Your Lordship, here, Your Lordship, as I have submitted, Your Lordship, since the recruitment was not as per the rule of 1986, Your Lordship, they have no right to claim for regularization or for equal pay for equal work. If it is a contractual appointment, the appointees come to an...
See, just come to this part. See, the High Court's acting under Article 226 of the Constitution should not ordinarily issue directions for absorption, regularization, or permanent continuance unless the recruitment itself was made regularly and in terms of the constitutional scheme.
Lordship, yes.
Because you see, we are not. You see, the things that Uma Devi also dealt with, litigious employment. Suppose a person being employed and is being sought to be terminated just on a contract upon without selection process, then they got from orders of the court. They continued. Now that was taken. That was also like that was frowned upon. Said like these people litigious who are operating under orders of the court then do not deserve. But the scheme was put in place like those people who have worked for more than 10 years before the judgment, then they were to be accommodated. That's the only thing. So that is, and in this, how do you distinguish your case from this case in the sense that okay, you're not conferring right because they're just daily wages, but they've come through they've come through a selection process. That's the only thing that's troubling the court.
Lordship, I have submitted your Lordship. Lordship will have to see the
terms of appointment, the mode of appointment,
the stipulation of the advertisement, your Lordship. That is why.
Another part is that now you have not shown anything to show that where is the communication, where is there were direct recruitment had been banned for a specific period. Any executive instruction. Because if these rules have been at 309, then
Lordship, if that be, then the Lordship, as I have submitted, they cannot turn around, your Lordship. They ought to have raised their grievances immediately, your Lordship. This is the rule. Why you have not? Why you have not done?
So you see, waiver, acquiescence, delay, those that go against them.
Yes, your Lordship. Now, after a period of 10 years, can they raise the grievances, your Lordship?
Fair enough. Yes. Yes. Next.
Then, Lordship, of the same judgment, your Lordship, para 46, your Lordship.
Doctrine of legitimate expectation.
Lordship, yes. Lordship, I'll towards the bottom, your Lordship, in moreover, your Lordship. Moreover, the invocation of the doctrine of legitimate expectation cannot enable the employee to claim that they must be made permanent or they must be regularized in the service, though they have not been selected in terms of the rules of appointment, your Lordship.
Yes.
Then 47, your Lordship. 47, 48, your Lordship. When a person enters temporary employment or gets engagement as a casual or casual worker and the engagement is not based on the proper selection as recognized by the relevant rules or procedure, he is aware of the consequence of the appointment being temporary, casual, or contractual in nature. Such a person cannot invoke the theory of legitimate expectation, your Lordship. As I have submitted, your Lordship, they are fully aware. They were fully aware of the nature of appointment, your Lordship. Then, so far, your Lordship, the argument that they are bound by the advertisement, your Lordship, I would rely on the 2008. Volume 7.
2008.
Your Lordship.
Volume 7.
Yes, your Lordship. SEC.
Yes.
Page 70. Lordship. Para 36.
70.
Lordship, yes. Para 36, 37, and 38. Lordship, kindly come to para 36.
6, para?
Para 36, your Lordship.
Oh, 36.
May I read it, Your Lordship? 36, para 36, Your Lordship.
Yes.
Again, when the fresh appointment order was issued and so by the governor and the appellant was posted on so-and-so, treating his first appointment order as a temporary appointment, no protest was made by him. In view of the fact that the governor issued an order dated so-and-so, even when order dated was in action, it is apparent that the appointing authority has also treated the first order dated so as an order of appointment on temporary basis. It is therefore apparent from the second appointment order that the appointing authority as well as the posting authority have all been treated the appellant as temporary district judge. But the appellant did not object on both occasions when he joined on so-and-so of he being treated as temporary district judge. The act and action of the appellant in accepting his appointment as temporary one amount to his assent to the temporary appointment, and the appellant throughout till he raised the objection on so-and-so has slept on his right of being appointed permanently on the post of district judge by his conduct at the time of the issuance of the order of the High Court on so-and-so, and therefore thereafter issuance of the second appointment order so-and-so on so-and-so with full knowledge of his own right, and the act of the High Court which infringed it led to the High Court to believe that he has waived or abandoned his right. Then 37, Your Lordship, Lord Campbell in so-and-so, generally speaking, if a party having an interest or to prevent an act being done had full notice of its being done and acquiescent it so as to induce a reasonable belief that he consent to it, and the position of the other is altered by their giving credit to his, he has no more right to challenge the act to their prejudice than he would have had if it had been done by his previous license. So he has all these 10 years.
This is the only very strong point you have in your favor. Yes. The board of the adjustment and the
regarding the equality of work, Your Lordship, I would cite 2003, volume 6. 2003, volume 6, SCC, page 123, Your Lordship, paragraph 6, 11, and 12.
This is
Lordship, kindly come to paragraph 11 or paragraph 6, Your Lordship. Answer. Paragraph 6, Your Lordship.
Yes.
The principle of equal pay for equal work is not always easy to apply. There are inherent difficulties in comparing and evaluating the work done by different persons in different organizations or even the same organization. In so-and-so, this could explain the principle of equal pay for equal work by holding the difference in pay scale among government servants holding the same post and performing similar work on the basis of difference in the degree of responsibility, reliability, and confidentiality would be a valid difference. The same amount of physical work may entail different quality of work, some more sensitive, some requiring more tact, some less. It varies from nature and culture of employment. It was further observed that judgment of administrative authorities concerning the responsibility which attached to the post and degree of reliability expect of an incumbent would be value judgment of the authorities concerned if arrived at bona fide reasonably and rationally was not open to interference by the court, Your Lordship. So, Your Lordship, here what are the
one thing, Mr. Shura, sorry to interrupt again. The thing is that you see the post of peon. What kind of duties entail? That's what is defined in the rules also, and they are appointed as casual peons.
They are casual only, Your Lordship.
Okay.
Casual only, Your Lordship. I'll come to their appointment also.
Okay, yes, no, that we've seen.
Lordship. Then can you see para 11, Your Lordship?
Yes.
A scale of pay is attached to a definite post, and in case of a daily wager, he holds no post. The respondent worker cannot be held to hold any post to claim even any comparison with the regular and permanent staff for any or all purposes, including a claim for equal pay and allowance. To claim a relief on the basis of equity, it is for the claimant to substantiate a clear-cut basis of equivalence and a resultant hostile discrimination before becoming eligible to claim rights on a par with other group based on alleged discrimination. No material was placed as to the nature of duties of either categories, and it's not possible to hold that principle of equal pay of equal work is an abstract one. So, Your Lordship, as I have submitted, Your Lordship, there was no pleading. What is the nature of work? That is silent. Then, Lordship, coming to the second advertisement, Your Lordship. Second advertisement, Your Lordship, because
that is page.
That is at page 81, Your Lordship. Lordship, this is the regular appointment, Your Lordship. In fact, Your Lordship, there is no bar for the writ petitioner to take part in that selection process, Your Lordship.
Election 12.
Yes, at page 81, Your Lordship. They are at liberty, Your Lordship. They are welcome, Your Lordship, to take part in the advertisement in this selection process of 2022, Your Lordship, because we have stated in the affidavit, Your Lordship, that they are free to take part, Your Lordship. For the reason not known, Your Lordship, why they have not taken part in the selection process, Your Lordship. This is a regular appointment, Your Lordship, in tune with the rules of 1986. So, in short, Your Lordship, my humble and respectful submission, Your Lordships, in view of the fact that the petitioners are not the holder of the sanction post, Your Lordship, the recruitment was done not as per the rules, Your Lordship. They cannot claim the right to.
Not only one thing. Where is that instruction that says there's a ban on regular recruitment? Can you produce? If you have made a statement affidavit, you have not substantiated with any document, with any material.
Then, Your Lordship, for that I'll have to call the officer for instruction, Your Lordship.
Because you cannot make a statement affidavit without supporting it with some material.
Lordship, then
you cannot just make a statement and say that this is because of that, and you don't have any other supporting material to say that this decision, this recruitment was entered into because of some pressing exigency.
There must be a Lordship. There must be.
Okay, we'll post it therefore tomorrow.
I just give a reply.
What replies, Mr. General?
One reply is very essential for me to give.
Yes.
Because one point he has raised that the appointment was not in accordance with the rules.
Yes.
To that he is referring Rule 16B relating to the age. That in the Rule 16B, the age minimum and the maximum age is prescribed. And so far the first advertisement is concerned, there was minimum age but maximum age was not prescribed. In that view of his submission is this, that the appointments were not in accordance with the rules. And he could cite only one example where person has attained, the candidate has
will not be eligible for the rules.
Yes. I just clarify that point, Your Lordship. Your Lordship will see Rule 16C. No, 1 minute. Your Lordship, page 25 of my rejoinder, which he has read.
Yes.
B. Must have attained the age of 18 years and not attained the age of 27 years on the first day of the year in which the interview is held. He read only this much. But there are two provisos which my learned friend possibly has overlooked. Provided that the upper age limit in any individual case may be relaxed by the appointing authority in accordance with any general or special order issued by government from time to time. This is subject to any order which may be issued.
We're not bothered with that.
No, Lordship, give me 1 minute.
We're not bothered about that submission. The other court submission which is made, which we are asking to substantiate, that's the only thing.
Lordship, With regard to the age, I'll clarify.
Age, this court is not taking that consideration.
Yes.
It's not a valid point for argument also.
Yes, because his contention that the that the appointments are not in accordance with the rules because upper age limit is not prescribed is absolutely hold no waters. The appointments
court 100% agrees with you. No water.
And the appointments save and accept this point. He has raised no other point that how and in what manner the appointments were not in accordance with the rules. It stands to no reason. And absolutely it is clear from the, where is the question of following reservation policy in the case of ad hoc appointment or casual employment? Where is the question of making ACR, giving ACR and police verifications? So another thing, Your Lordship, he has also raised one point that the terms of appointment. Now, terms of the appointment, Your Lordship will find that the first appointment of 60 persons were given for a period of 1 year. After that, terms of appointment, even if they take it, that terms of appointment expired after 1 year. After 1 year, how they continued, on what basis they continued?
Yes.
There is nothing. They were treated for all practical purpose as a permanent employees. And another point which he has said
now,
that
daily wage. Now, what is the scope? Daily wage earners. That means you paid. How you paid? Every week or every day?
No, consolidated.
Monthly, Your Lordship.
Then how will it be delivered?
Now they have been paid 15,000 per month, Your Lordship.
Per month. Under the Minimum Wages Act.
Okay.
Under the Minimum Wages Act, the Labour Department issues the notifications.
So daily wage
and daily wages are different because the RTI information which I have submitted yesterday, that shows two categories. One category is purely daily wages who has just entered without any interview and selection process.
Yes.
They are paid on daily wage basis. For holidays and Sundays they don't get any pay. But those who have come through the selection process, they are paid consolidated pay. And presently, earlier it was 13,600, and now they have recently they have raised to 15,000. Whereas,
so we get it. No, that you showed that those who have come to selection process, they paid at minimum wages. Those who come like that are paid daily wage.
Daily wages. Another point, Your Lordship, my learned friend has raised the point that I have raised no foundation for equal pay. That foundation, Your Lordship, is raised first in the writ petition at paragraph 3.5. Yesterday also I have read it, and he has given a bold reply by saying that statement made in para 3.5 is denied. And thereafter, in the rejoinder, I have completely explained, and I have annexed the copy of the manual of the duties and elaborate and demonstrated that they are performing the same duties. Rejoinder is a part of the pleading.
Let them produce that. Let them produce that. Yes. Let them see them. Your client is not here today.
Today they are not here.
Very contemptuous attitude yesterday.
Because everybody they are
very contemptuous. Addressing
they want to check me.
Addressing the court by sitting and not even just saying no.
Even I didn't notice that anybody has come.
You should tell them at least. Just the conduct means they're not fit for realization. That's all in jest. Yes. Because when you want it?
Monday.
Yes. Lisa's matter on Monday for further hearing to enable Ms. Anishulai to produce further instructions.
Instead of Monday, Your Lordship, because Monday I have got 5 arbitration appeals.
Doesn't matter. Mr. Kumar is here.
If any reply is needed, then Your Lordship.
Tuesday.
Tuesday. What is the date? 23. Tuesday 23.
When?
23.
On 23rd, Tuesday.
Okay.
You produce it because you have made a statement affidavit. We are giving you a chance because that's the only thing.
Offline, Your Lordship.
main list, item number 16.
Yes, Mr. Mazumdar. Yes.
This matter pertains to dismissal from the service lordship, and the impugn order is reflected at the page 20 of my petitions.
Where's the local council?
My lord, that local council is student not available, lordship.
Then we fix another date. I'm not comfortable. Just help the local council to. When was this case filed?
Case was filed on lordship in 2019.
He was dismissed in 2003.
Initial order was on the 2003 lordship. Thereafter, he approached the High Court of Allahabad. This order is reflected on the page 27.
Okay.
Page start from 26 and 27.
Yes.
And the High Court of Allahabad directed him to file a representation before the authority to consider his case. And thereafter, his representation was rejected on 2018 lordship, and it is reflected on page 31 and Annexure 6 June 2018.
Speaking order.
And against this order, lordship, that he approached this honorable court.
What ground are you challenging the dismissal order?
Lordship, that his ground is that the inquiry report was not served to him. He was declared a deserter, lordship, before findings of the deserter, lordship, that report has not been served to him.
Correct.
That is the first one.
He is not traceable, my lord.
Oh.
In case of desertion, what happens, my lord? We conduct some kind of inquiry. We request the state police also to try to locate him in some copy. And when a report came from police, my lord, that he is not traceable, then we start the proceedings and conclude that, my lord. This is a case, my lord, where he is coming out with some pleas now, but he was arrested in connection with the NDPS case, my lord, in Manipur.
In
Manipur, my lord.
But the thing is that he was not known that he was in custody.
We didn't know. He never informed us, my lord.
Lordship, in connection with the NDPS case, the investigating agency has filed a final report notice. It is reflected from the affidavit of the respondent.
No, at that point of time when you were arrested, you were on unauthorized leave.
Lordship.
How many days were you absent?
Lordship. And the another aspect, lordship, the petitioner has in the service for 19 years 6 months. So without any red entry in his service book. And thereafter, this order of dismissal has been passed.
Till 2003 when he was dismissed from service, my lord.
Anything else to add?
Lordship, he joined on service on 1974, and he was dismissed from the service on 2003, lordship. 29/7/2003, with effect
no, is
from.
It correct? You disappeared from 1993 till 2003.
Till 2003 when the impugn order was passed.
Then after the impugn order was passed, how did he come to learn about it?
Then 2017 he approaches Allahabad High Court, my lord. For some reason Allahabad High Court gave him liberty to file a representation at that time. Whether they revive the entire prosecution was that's for another question.
Yes.
So, lordship, that the punishment is one of the ground is the punishment is the disproportionate. The person concerned is as on that age about the 63 years, and if his punishment is converted into the compulsory retirement, lordship, then also because as on that his age is 62 years, 63 years, and since 19 years 6 months he have a very good service record. So if it is converted into the either compulsory retirement or in the voluntary retirement, then also, lordship, he will the satisfied, lordship.
Anything else?
And the plea he took, my lord, when in the present petition that he was abducted by NSCN, my lord. That is the plea. He is lying here also.
Here in the petition? Is that correct, Mr. Mazumdar? Where have you said that?
Yes, Lordship. When he was returning from the leave, Lordship, he was kidnapped by the miscreant, Lordship. That initially on
how many? So you stayed 10 years. 10 years you stayed with the miscreants.
No, Lordship.
Then
on 7th, he was on the leave from 1/10/1993 to 20/10/1993. And when he came to the duty to report back on 17/10/1993, he was kidnapped by the miscreant.
And after he started dealing in drugs. Then?
And thereafter, Lordship, somehow he came from the hand of the miscreant. And
where's the report? Where's the report that you filed with authorities that you had been abducted and that you escaped from the clutches and that you reported back for duty?
Yes,
did it come out in the newspaper anywhere that you made a miraculous escape from militants?
Lordship.
No.
That.
Oh, you're staying with them as their guest?
Lordship.
Okay.
And the dismissal order was passed on the 3 occasions. First on 2003.
So see, read para 6. Very interesting.
Para 6, Lordship.
Yeah, just read. He escaped from the militants and he was arrested by excise officers.
Excise officer in connection with an NDPS case. In the NDPS case, Lordship, the final report has been filed by the investigating
authority. That is because lack of evidence. But as per his statement that the President State somehow managed to escape the clutches of the militant and tried to reach a nearest police station in Dimapur to see, but unfortunately he was arrested by excise officers and false fabricated charge leveled against him that he was trafficking ganja. So you think this kind of a track record deserves any consideration by the court, Mr. Mazumdar?
Lordship, that
we're going to discipline force. We'll pass orders.
Falsely,
yes.
Lordship, that.
Thank you.
On the 2nd week of June, Lordship, this matter may be taken up.
Second?
2nd week of June, Lordship, if possible.
Okay, we'll give another chance. 2nd week of June.
2nd week of June, Lordship.
Okay.
19.
Is there?
You escaped from clutches of militants and straight into the arms of excise. That is a nice story.
Sometimes people they might
yes.
their version, Your Lordship.
Today, I think the counsel for district council was supposed to file affidavit. He was asked to file affidavit, I think, on the last date.
Where's yes?
He came.
Where's he's here?
In my humble and respectful submission, Your Lordship, the record will speak by itself, Your Lordship, if it may not be necessary from the district council, Your Lordship.
What's your prayer here, Mr. Bora?
The one for quashing of one order passed by the government, Your Lordship, where we have invalidated the rule framed by the rule, Your Lordship, framed by the Hasil Autonomous District Council, Your Lordship.
So how can we?
Lordship, one of our contention, Your Lordship, is that the locus of the petition also very important, Your Lordship. Then another aspect of the matter also, Your Lordship, is that
Regarding that, I have.
That is Annexure 3.
Lordship.
The publication in the Gazette, that's all, not authorized. Annexure 3, page 23 of your petition, Mr. Bora.
That is.
Lordship, yes.
Yes, Annexure 3. I have submitted and I have also averred under paragraph 6 F. Like this, the notification was supposed to be of 2015. During that time, the state had appeared in 2 writ petitions, one of 2015, one of 2017. But they did not produce that notice during that time. That means the notice was not existent at that time.
We can't make this kind of, this is a Gazette notification. We have to give.
Stopil is there. Because that time they could have produced, they have not produced.
Now, what do you want this court to do?
That this notice
to set this aside and then to say the rules were authorized, were published in an authorized manner.
The rules are being implemented. They are being implemented now also, yes.
Is that correct, Mr. Ganta?
Opinion songs are in Riboy also.
Mr. Ganta, is that correct?
They are appointed.
Is it being appointed as per the rules or customarily?
As per the rules, yes.
They're two. See, if custom existed, codified rules made, then as per applicant of rules, maybe you say now it's codified. But if custom existed, codified, gazetted, has been stayed or set as or has been set unauthorized,
this notice has
but
said
then
only the
customarily
publication is unauthorized. This notice does not say that the rule is unauthorized or rule has been repealed. It says only the publication is.
Yes, so unless rules are published in the Gazette, they will not have the force of law.
No, the publication thing is entirely of the Secretariat. District Council has got nothing to do with it. Whether somebody has to sign, it has to go from one table to another.
Why
That is in the Secretariat.
Mr. Shulai?
Lordship, there is, we are fine with it.
No, why just say from the affidavit?
On the same subject, there were 2 writ petitions earlier to this. They did not produce it during that time, till 2018.
The earlier proceedings, he had come for seeking a definition in the rules with regard to the term mulor, correct?
Yes.
And so the courts can't direct legislative bodies to enact.
No, we had only asked that when it is republished again, if it is published again, at the time to give the meaning of the word.
Because it was not as per.
A word has been used in the rule.
Why
without giving a meaning of the word?
It was not as per the established procedure under the Meghalaya Secretariat Manual of Office Procedure 1993.
That is procedure of the Secretary.
That has been corrected now. What is the position now? From 2015, it remain like that.
Lordship, in fact, Your Lordship, this rule, Your Lordship, since it has come before the Honorable Court, Your Lordship, this rule cannot be enforced, Your Lordship, even in Maharam Ship. Lordship, if
we're not talking about enforceability. We're talking about there has been a rule has been made.
This provision has been.
It has been
provision to Rule 5 has been implemented.
It has come out before in the Gazette. It becomes law. Correct. Lordship. Now you have produced. You have made a notification 2nd December 2015. You write welcome notice so and so that a notification number so and so and so and so was published so and so, and then whereas the paragraph so and so of the Meghalaya so and so, then that the above procedure has not been followed in the publication of the notification. It does not say that it's unworkable or that it's extra constitutional or it's ultra virus the Constitution.
Lordship kindly see. Now the District Council in each and every HIMA, with the exception of few, Your Lordship,
They made rules.
They have made the rules. They have made they have codified, Your Lordship. One of the in Maharam there is an act, Your Lordship. It is called the Khasil Autonomous District Nomination and Election of the CM, Deputy CM, and Elector of Hima Maharam Act 2006, Your Lordship. Under this act, Your Lordship, in section 11, it says like this, Your Lordship: the provision contained in the United Khasi Jainti Hills Autonomous District Appointment and Succession of Chief and Headman Act 1959 as amended shall on and from the commencement of this act no longer be operative as far as the Hima Maharam is concerned. Then Lordship kindly come to the rule framed by the District Council. Lordship will find it at paragraph at Annexure 1 at page 12, under of the writ petition, Your Lordship.
Yes.
This rule, Your Lordship, has been framed by the District Council under the United Khasi Hills Autonomous District Appointment and Succession of Chief and Headman Act 1959. Lordship,
Where is that?
Lordship, I kindly come to page.
Yes, preamble.
Your Lordship. Preamble, Your Lordship. Whereas, Lordship is with me.
Where's the Maharam Act now?
The Maharam Act is here, Your Lordship.
Is it published?
It has been.
It is old.
Have rules been made under Maharam Act?
Maharam Shameship, that act is very old. This has been modified and the 2015 rule has been made, combining all. So that all the non-Khasi villages and the Garo villages, they get non-Pinyan Shnong.
Of the Act of Maharam, Your Lordship, there is a rule-making power of the executive Darbar of the CMC.
In the old Maharam Act?
2006, Your Lordship, yes.
So no rules were made by Maharam Shameship.
No. This place is not within Maharam.
No, that is not his case. His case is that we were given the definition. What has been given has been taken away by your gazette, by your notification saying that the early publication unauthorized. That's all.
Lordship will also.
Now, whether now you say the rules don't exist, Mr. Jakinta, what do you have to say?
It's not exist.
Rules have been implemented.
According to me, it is we are enforcing the rules from time to time.
Then what is the grievance? The rules have been enforced.
My grievance only that the word Muller has not been defined in the rules.
Or the new rules have not come again, Muller. But the rules now.
This rule is being implemented.
The
Muller word has not been defined.
See, the thing is that now rules have been made. They said that they're following them. These rules have been declared unauthorized by state government. Correct.
Yes.
Now you're seeking amendment of the rules to insert the definition of Muller into rules which have been published.
We just want the meaning of the word. That's
it's like an amendment to the rules to insert the meaning of Muller in the rules have been declared unauthorized, which are being I don't know which way they're being applied. Mr. Kanta, that is a very it can't be legal fiction also.
Lordship, kindly see.
We can see. How will you decide a case like this? Now can he get into relief when unless the what has the council done about this notification of December 2015?
They are putting the gun, Your Lordship, on his shoulder and shoot me, Your Lordship. They are shooting me. Lordship, so far his contention that the word definition of Muller. In fact, that was the earlier in the earlier writ petition, Your Lordship. Kindly come to page 20, Your Lordship, of the writ petition. Annexure 2.
Yes.
Lordship. Function so then Lordship. Lordship, kindly come to the next page up 21. Then Lordship, kindly somewhere in the middle the grievance.
Yes.
The grievance to be suggested this is that the expression Muller has not been defined. So
that is the grievance. Yes.
From that time, that never been defined till now.
Not yet defined.
Then we can't direct that. You're covered by this order.
That cannot be directed. It was said before also. Now we had requested the district council for whenever if it is published again to give the meaning, or otherwise also give the meaning of the word.
Now the rules are not existing on paper. They are existing on the ground as per submissions of the senior
word
council.
Muller is there and without being defined. That's not even an English word. We'll find in a dictionary.
It's Urdu.
This word Muller.
Where
it is in the rule, and rule is being implemented.
From which language does it come from? Mular means from which language?
Mular means a headman of a Garo village.
No. Where does the term come from? Is it a Garo term or is it a
from
Maram
Garo
term?
villages? It's
a Garo term.
It's actually not a Garo term. It is actually Bengali term. It has come to the Garo. Bengali term actually.
Then, Lordship, kindly come to page 22 of that order passed by the division bench of this honorable court, Your Lordship.
Yes. No.
There is also a title suit pending, Your Lordship. While examining the order dated so.
What happened to title suit?
The title suit has been missing. It had been called by the court. Then it was returned from this court. I had reported the matter to the court also. And direction was given to find out. And there I could not find the case record. It has not come to the district council court again. It has not gone back from.
Mr. Bora, you come up with the most peculiar kind of cases I've seen.
Then, Lordship, it says, the order says, in the given sets of circumstances.
No, it's all right. They don't find a business.
The case records were called.
See, now coming back to this proceeding before this court, what kind of relief will be entitled to? What can the court do? Court understands your anxiety and your concern that you're exercising this traditional office now which has not been defined. So all is seeking some recognition by way of definition to be put in the rules that I am a mular and I should be treated as such. Yes, that's all. Like
that's all.
That's all, like a lingua or a headman.
Or they can give them. Otherwise, also they can give whatever has been written in the rules. The word mular means so and so. So just
we can't direct that, Mr. Bora. How can a court direct that the rules be made when the rules are not operating anymore? So.
Rules are being
where I mean
being implemented
if once that gazette notification that has been printed, it has been withdrawn. So where does it leave us?
It has not been withdrawn.
We're running in circles.
The district council has been implementing it in various places.
Mr. Kinta, I think you have to suggest a way out. You can't just wash your hands off and the rules don't exist and you're seeing implementing them. Can that be accepted?
You'll have to re-examine, Your Lordship.
I just want to say this, Your Lordship, that after the 2015 notification declaring the rules frameworks to be unauthorized, we are working on this matter to bring out a fresh rule. And
then you go before them.
Yeah, when the fresh one comes, then we want that the meaning should be.
Then they're working on it.
Yes. We can wait.
Then you will dispose of you. Yes. You listen to them.
Yes, at this stage.
Yes.
They have a grievance, they can write to us.
Right. That's what I'm saying.
Yes.
At this stage, this repetition is.
That can be a good solution, man.
Okay, we'll dispose of it down.
Yes.
Otherwise, we understand your anxiety. You can't just exist without, but then these matters. Stop the writ petitioner. Who stated to be this is who stated to be a mular, a headman of a Garo village, is before this court seeking a similar prayer that has been sought in the earlier rounds of litigation, wherein this court, in the last order passed in WPC number 341/2017, by order dated 11/2/2019, had disposed of the writ petition No?
This court in last court of passing by order dated 11/2022 and dispose of the litigation.
By directing as follows. Quote the entire order. No? It's annexure 4/24. From the above quoted order, the same issue that being canvassed in the earlier petition has been brought again for consideration before this court. Stop. Looking into the totality of the circumstances and also consequent on the submissions of the learned special counsel for the district council that on the earlier rules being declared as unauthorized, the respondent district council is working on framing a fresh set of rules. Stop. It is therefore only fair that the writ petitioner be allowed to make a representation before it's a rule-making committee. What's it called? Before the executive committee, KGTC, which is seized with framing the fresh rules for inclusion and for definition of the term of Mulor.
Yes.
As headman of Garo village. Stop. Next paragraph, the said representation shall be preferred within a period of when? You'll file it when?
I'll file it next week.
You'll file within a period of 2 weeks from today, which shall be considered which shall then be considered by the council when the rules are finalized. Yes. Next paragraph, writ petition only stands disposed of.
Apply or not?
Item 22.
My lord, here I require some accommodation, my lord. This is matter pertains to ACP, non-grant of ACP, my lord. So, some
ACP upgradation, ACP or what?
It's a they are saying that there's
upgradation is your ECP.
Yes, my lord.
This is
a different case.
And plus,
okay.
And here the scale also.
ACP, he has to qualify because ACP is in place of promotion, my lord. So he has to meet the promotional criteria, my lord. So
Promotional criteria, my lord. That's required accommodation, my lord. Promotion.
You meet the criteria.
Yes, my lord.
He met, but later.
So you're deprived of your first ECP.
My lord, he was delayed, my lord, because he did not pass certain departmental examination in time, my lord.
Okay.
So, come to
so when do you want it?
My lord, next week.
So on the prayer of Mr. Argaha to seek some accommodation in this matter after 3 weeks. This court won't be around for quite some time.
23.
Yes.
Same, my lord.
Won't be here for some time, and it's not around. Yeah.
25.
Lordship, in this case, the conducting counsel is on lag before.
Who's conducting counsel?
Ravi Guru.
Who's for the petitioner?
Mr. Sangesu.
Where's Chanreso?
But there's some urgency. I'm to the private respondent, my lord, because of the pendency of the matter, the appointment has been withheld.
Of the?
Of the private respondent.
Just give me 5 minutes. Let's come back. Private respondents, you're paying private respondents.
I'm the selected candidate, man.
The matter may be passed out for a day, Your Lordship. Just for a day.
It's very urgent.
Only for 2 years, government is not issuing appointment letter.
They can't wait for 3 weeks. This is after 3 weeks, yes. As the arguing counsel for the state is not present. Yes.
28.
We'll just remind, you can mention it. I'm saying on the record, mention it, we will take it out.
28.
My lord, this is a for regularization of the sweeper and cleaner in the
Yes.
My lord, yeah, the petitioners were in the working in NEPCO, my lord, as a sweeper and cleaner since 1995 onwards till date, my lord. My lord, pursuant to the order of the Honorable Court, we have to file a representation before the authority, and the authority has to pass a speaking order. My lord, that speaking order is under challenge before this Honorable Court.
Where is the speaking order?
That is, my lord, at page 28.
28? 28 High Court order.
My lord, that speaking order typed copy is at
27.
27, my lord.
27, yeah, okay.
Next to 5, my lord. My lord, in the speaking order, my lord, the grounds they have taken, my lord, that my lord, the no sanctioned post, my lord. They don't have any post of sweeper and cleaner in the NEPCO, my lord. And they are, it is an admitted fact that they are working there. If there is no sanction post, my lord, the question of their even a daily wage earn does not arise, my lord. My lord, in contrary to the impugned order, my lord, the petitioners, we have taken a whether that RTI, in reply, my lord, similarly situated persons has been regularized. If no sanction post, that RTI, my lord, page 25, my lord.
If you listen to proceedings of the court, that young man there, come here in front. You're who's junior? Who? Pinong Bri. What's your name? Jigsaw. If you observe proceedings of the court, observe him, you keep your phone somewhere else. Okay? Sorry, don't play music. No, it's all right. You're a young counselor, so I'm telling you, otherwise I won't say. Yes. Yes.
My lord. My lord, we have taken a RTA. Whether that
was RTI.
My lord, that RTA annex 3, my lord.
Page?
Page, my lord, 24.
Page?
My lord,
24A, 24, what is this? 24?
24.
Annexure 3.
Annexure
Section 3 is speech 24, yes.
My lord.
Stitch, no, can't make out also. Anyway. Yes. Now what you want to show by this?
My lord, in that, my lord, on the top only, my lord, it's a list of regular sweeper and cleaner, my lord.
Okay. Yes.
My lord. If regular sweeper and cleaner, my lord.
Where's your query? Let's see. Where's the RTI query? You're not next in. No, never mind. Yes. So according to you, there are 26 regular sweepers and cleaners.
My lord. The first contention that the post is not sanctioned, my lord. If it is not sanctioned, then how they have regularized them, my lord?
They've been regularized.
Regular sweeper and cleaner, my lord.
Yes.
My lord, and they have been paid with even in violation of a minimum wage, my lord. They had to 3,000 rupees, my lord. For a month, my lord, 3,000 rupees. That is also violation of the, we have taken a stand, my lord. It's a violation of, and past 30 years, they are still in service, my lord. So it is, they are covered with the exceptions as laid down by the Honorable Apex Court in the Umar Devi case, my lord. There was no stay, nothing is. So, and at this stage, my lord, in this scenario, my lord, serving with a minimum wage is 3,000 rupees.
That's not minimum, that's less than minimum.
Very less, my lord. Can't be survived, my lord.
Yes. Now, this list, from this list, Mr. Jha,
my lord,
have you said anywhere which are the people who will, they all appointed the same way, daily wages? Have you made a statement anyway that when you qualify your Nature 3, you say they fill up a regular appointment. Now you appointed daily wage basis, that means which year you said, 30 years ago?
Yeah, 1995, 97.
30 years?
More or less, my lord. Even the some of the petitioner is 1987 also, my lord.
Even up to 17, there'll be 20 years, will be 25 years.
Even 10 years, my lord, the Umadevi exception says minimum 10 years.
So what did they see in this being order? Why did you not giving? They said
that no sanction post.
Backdoor entry.
Backdoor entry.
Yes.
My lord, that page para 14.
No, one thing just clarify, are you part-time or daily wage?
They say that it's daily from 11, no fix tenure, my lord. My lord, if I, as far as the pay revision and others, my lord, they are entitled.
Where's that query? Now, only the thing is, who are those regular sweepers? That's the only question that you have to answer.
My lord,
Who are those regular
page
sweepers,
31. Page
Let Mr. General answer.
Oh, my
Who are those regular speakers or regular sweepers who've been shown in the RTI reply?
Your Lordship, they were appointed long before through the due selection process, and none of the case is a case of regularization, which is contending. And moreover,
Have you stated that in your affidavit?
Yes, Lordship.
Where's that?
Para 15, no, page 15. Of my affidavit, that thus there is no such information provided by the respondent corporation under RTI, that said posts are not advertised and has not been published by the department as released by the petitioner in the writ petition. The contention of the writ petition that only 26 posts were occupied and that there are still 19 posts lying vacant are not correct and hence denied. The deponent submits that out of these 6 number of regular posts of cleaner and 39 posts of sweeper, total 20 number of posts were filled up during the period 1990-95 by way of regular appointment following the due recruitment procedure, and none of the post was filled up by regularization. And another aspect your Lordship will find in his writ petition, paragraph 4. And the nomination were obtained from employment exchange candidate, were shortlisted, interviews were held, and panel of the selected candidate were drawn up, which was followed by issuement of and the writ petitioner deliberately intentionally twisted the information provided under RTI. So there, and so far these petitioners are concerned, your Lordship will have a look on paragraph 4, page 9 of his writ petition. What is the nature of the appointment? Paragraph 4, that your humble petitioners are working as part-time cleaners. They are only working for 3 hours in a day and getting a fixed salary of 4,000. And no, it has been enhanced as per the Minimum Wages Act. So in every offices these days, your Lordship, these sweepers, they come morning 1 hour or 2 hours, they clean the office and go away. This is the practice in almost all the office, and they are paid consolidated salary of 4,000.
Now just come to this list, annexure 2 or writ petition. Now the names are here of all these petitioners. Is it the annexure 2? Just see, Mr. Jha, at page 22. Where are the names of the petitioners? They here?
Page 22
of your writ petition. We have the record with you of the query, RTI query.
My lord, it's they have annexed in page 31, my lord. Of
No, just answer this question first.
My lord.
Is the names there?
Yes, my lord.
They're all here?
Yes, my lord.
All of them?
My lord.
How many petitions are here?
My lord, 13, my lord.
13 petitions in your writ petition?
Yes, my lord.
All of them, but then see the heading of on top, list of part-time sweepers and cleaners.
Yes, ma'am.
I think, Mr. Jha,
My lord.
I guess when you explain to your clients, it's very difficult. Because the terms of appointment is not annexed also, and if they appear in the name of part-time sweepers, which is distinct from the list of regular sweepers. So,
my lord, even the regular sweeper, my lord, which they have stated that some employment exchange and everything, that formalities only they have appointed me, my lord. After formulation of they have not annexed any advertisement which has been made, and they are taking the stand.
You appointed against advertisement.
It's they are saying that have been appointed, my lord.
That you have been appointed, right? Whatever it is. Now they are saying that is a backdoor appointment.
They are saying, my lord.
Number one, backdoor appointment. Number two, part-time appointment. Number three is not against any sanction post. So that disqualifies you, firstly, because you're not appointed for selection process. Number two, that means it's not against any sanction post. And there was, what's the third point? Yes, no selection and not against sanction post. How can you be regularized then?
My lord, as far as the advertisement, my lord.
Where's the advertisement?
It's the affidavit is silent, my lord.
Lost advertisements there? No advertisement.
The advertisement affidavit silent.
These posts, your lordship, are taken through the employment exchange under the Act. There is employment.
So you write your requirement.
Regular vacancy, publication of the Vacancies Act, which requires that the requisition is sent to the employment exchange, that we have this many posts, then they send the candidates according to
no selection.
Then selection process is carried out.
So they went for a selection process.
They process selection process. And
what's the difference between selection process for them and for the regular sweepers?
They are just taken.
No.
There is no appointment letter issued to them.
No, what this court is saying is this, that for the regular sweepers, what is the process?
For regular sweepers, through the employment exchange.
And for them, it didn't go to employment exchange?
No. And another aspect of the matter, your lordship will see, this is a third round of litigation on the same issue. In the first round of litigation, the writ petition was disposed with a direction to make a representation before the authority concerns. In pursuance to that order, he made a representation, all these 13 petitioners. They were given right of hearing and speaking order was passed. Then he filed a second writ petitions. During the course of the hearing of the second writ petitions, the court hearing the matter at that relevant time passed an order asking me to explore the feasibility of creation of post and to take up the matter with the ministry so that post can be created. We have put up the matter before the board of directors. Board of directors said that we cannot create the post for this part-time employer. And
no, part-time, there cannot be a post against part-time. That is very nature that says part-time is part-time.
Part-time only. That they come for 2 or 3 hours.
You discuss with your clients, but I think very difficult for them to be given relief. Or you want the court to dispose of now, or at least you prepare here. I understand if they've come 3 times, they're very desperate.
My lord, 3 times means in the second one, my lord,
you bring some records, bring the queries. Regard appointment regular.
Those are already annexed, your lordship.
Yes, at the request of the council petition, this is a matter of 3 weeks. You prepare. Otherwise, there's nothing in the case, Mr. Jha.
But it's like hard a little bit because
matters heard at length. Yes, Mr. Jha, please me without to receive some instructions. Matter stands adjourned, listed on so and so.
31.
May I please, your lordships, I have filed in miscase, my lord, because my case is lie on that call for the record, because all of them in the non-gov LP school, not even a single MTET qualified candidate or appointed, my lord.
We're not calling for the records, Mr. Hazarika. I remember this case, I think. You filed yesterday?
Yes.
There is a disparity and discrimination.
You're not qualified. You're not qualified.
She is not qualified to be appointed as teacher because she is not qualified to enter your lordship. As per direction, your lordship, I have filed the instruction from the government and it is on record also. It is taken on board.
No, only my contention is that, my lord, not even a single non-govt LP schools. All the teachers are non-MTET qualified candidate who was appointed and approved. I have annexed these two approval order also. There is a discriminating and
I think if I
disparity.
remember correctly, we said that you cannot seek negative equality.
No, there is the disparity.
One wrong doesn't make two wrongs or 10 wrongs.
No,
another right.
It is okay, my lord. If in case of 1 and 2, it does not matter. But entire district, my lord. Entire district. 1, 2, it is
then
okay.
you have to dismiss all those teachers.
But earlier in the main petition, your lordship, this plea was not there. Now suddenly after submission of additional documents from the government, now means my learned friend has come up with this miscase for records, your lordship. So this is not your lordship.
It is correct, my lord. It is correct. Subsequently, you came to know that all the these things not qualified candidate are appointed in other school. Why the disparity is there in my case, my lord.
This case only, your lordship. Even we have filed our reply also and instruction as per direction of your lordship.
It's simply, my lord, this is the record. Only 10 school, my lord, if not entire. The 10 school name I have already put. Yes, if they will bring that record, so matter will be clear, my lord. My case is lie on that only, my lord.
So earlier, then your lordship, earlier order or whatever passed, all will be nullified by this case, your lordship.
Read petition.
Moreover, all illegality occurred while taking interview and all, your lordship.
No,
During
that is
COVID
another question, my
your
lord.
lordship, without
Main contention, I am not MTET qualified candidate.
Interview was also held without the consent of the subdivision school education officer.
It is there.
And she is the only candidate who appeared because there was a COVID restriction.
No, that is there. But in case of others school, there is no restriction. COVID restriction to keep the distance only in 2021.
See, this court cannot go beyond the rules and say that a person who does not qualify for NCTE norms be given approval. And the negative
that is there, my lord. But in case of 1 and 2, it is okay, my lord. But there is a disparity, my lord.
You can't advance this kind of arguments.
Because 2 approval is already given, my lord. If it is 1 and 2, entire district.
It's not a question of not being qualified. The entire exercise of the interviewer was tailored to meet your needs only. During COVID time, you appeared alone and selected, bypassing other officers.
In the COVID time, this other 2 school also they have conducted interview.
They have filed a PIL.
Yes, my lord.
Yes, sir.
Yes, it is.
That will be better, but in this case, he cannot.
So, my lord, it
will
may
be
come
dismissed
after
this
2
case.
weeks. So,
Come after 2 weeks.
2 weeks, yes, my lord. So, I will make an argument on this point.
Okay, make argument. Yes, the miscase noted MCWPC 35-2023. This miscellaneous application 35-2023 miscase have been filed a petition seeking for production of records with regard to the appointment of other teachers, assistant teachers in
my lord.
in non-government aided and SSA lower primary schools in Southwest Garugas. The same is noted and taken on record.
Yes.
This miscase along with the main case for final hearing after 3 weeks.
Yes. Much okay, sir.
32.
The bank case, my mom. The bank case, my
Lordship, I'll have to take this honorable court to my writ petition where I wanted to exhaust everything and including the precedents and petition.
You can finish by 1:30 the entire hearing.
Our
contents are very limited. We are saying that since you are giving prospective regulation, you are not entitled to the old pension scheme, and they are agreed by that very clause, saying that if we have already joined prior to 2010, and our regulation should not matter, and we should be governed under the old pension scheme. So that
Let him
is
start.
I draw your lordship's attention to my writ petition. I'll try to finish within one. At the very outset, your lordship, I'd like to state that the petitioners are approaching your lordship for justice through these common petitions, espousing similar and common cause of action based on similar.
How many petitioners are there?
22.
22.
I'm reading my petition, your lordship, paragraph 2. That I'll go to paragraph 3. The, paragraph 2, it is the authorization to one person to represent. Now, paragraph 3, your lordship, that in terms of an advertisement number so and so, 27 September 2007, issued by the Directorate of Account and Treasury inter alia inviting application. This is at page 5.
Page 5?
No, where's the... Oh yeah, this one. This is at page 23, your lordship. Not page 23.
No, 23 is authorization.
It's at page 26.
Okay.
This is issued by the Director of Accounts and Treasury, Shillong, advertisement number so and so, 27 September 2007. Application in prescribed standard form are invited from eligible candidates and residents of Meghalaya for temporary appointment as junior divisional accountant under 3F of the MPSC Limitation of Functions Rule until regular recruitment through MPSC and appointment is made in accordance with the service rule. The post carries so and so, so and so. Now, annexure A2, A3 up to annexure 5, they are the advertisements, your lordship. Now I come to my writ petition. That the petitioners were subsequently made to undergo rigorous selection process after they came out successfully in the said selection process and were further certified to be medically fit with verified character and antecedent. The petitioners were appointed to the post of junior divisional accountant under Regulation 3F of the Meghalaya Public Service Commission, etc., 1972, and posted at different offices. The table below shows the respective orders of appointment against respective petitioners as herein below. All these appointment, your lordship, if your lordship peruse, they are all prior to 2010.
8, 9, 9. Right. Okay.
They are all 2008, 2009, 2009, 2009. Then I have annexed those things at annexure 3, 4, 5, 6. Now coming to paragraph 5, that in terms of the opposite appointment orders at annexure 3, 4, 5,
this
6.
Is all under 3F.
All under 3F, lordship. Now, date of joining, all prior to 2010. Paragraph 6, that after joining as above in the initial place of posting, the petitioners were subjected to transfer posting at different places. All the petitioners have by now been allowed to cross efficiency bar with effect from 1/7/2016, notionally as per office order number so and so, dated 9 November 2021. That is annexed at annexure 7. Your lordship may have a look at later. At this stage, paragraph 7, that subsequently the services of your petitioner originally appointed under Regulation 3F of the Meghalaya so and so 1972 stood regularized by virtue of the approval of the Meghalaya Public Service Commission.
Regularized from which date? From date of initial appointment?
Yes.
From 3F appointment to regularized.
Yes, lordship. as conveyed by Commission letter number so-and-so, dated 2nd March 2020. Consequence to the Commission's approval as conveyed by letter dated 2/3/2020, the Government of Meghalaya and the Finance Department dated 19 February 2021 inter alia conveying the approval of the State Government for regularization of altogether 38 junior divisional accountants, including the petitioners herein. The names of your petitioners appeared against serial number 1 to 19, 25, 26 and 27 only of the letter dated 19/2/2019. Copy of the Commission's letter is at Annexure 8, Your Lordship. Your Lordship desire to read that? Annexure 8?
No, we'll have to see that also.
Okay. Page 38, Your Lordship. Regularization subject. Regularization of JDAs appointed under 3F of the MPSC LOF 1962. With reference to the subject and letter cited above, I am to convey the Commission's approval for regularization to the so-and-so under 3F. Now, I have a consequence to Annexure 8. The Finance Department, by means of letter number so-and-so, dated 19 February 2021 inter alia, conveying the approval of the State Government for regularization of 38 so-and-so, and this is at Annexure 9. I'll come again to Annexure 9 later, Your Lordship, or I may read at this stage, which is at page 39, Your Lordship. Dated 19 February 2021, regularization of junior divisional accountant appointed under Regulation 3F of the Meghalaya Public Service Commission, limitation of functions 1952. Now, the names, Your Lordship, I have indicated, they are reflected at Annexure, serial number 1 to 19 of this Annexure A9, and serial number 25, 26 and 27.
Now one thing, just hold it. Now, as per those existing rules, is like services under 3F accounted towards pay, increment, pension, etc. Correct?
Yes, Your Lordship.
So what's the problem then?
No, I come to that, Your Lordship. Let me come to that. Now, at page 40, Your Lordship, to make matters short, the regularization is however subject to the following condition as stipulated by Personnel AR Department letter number dated 27 August 2007. Your Lordship may desire to peruse this letter dated 27 August 2007, which is annexed in the additional affidavit.
Whose affidavit?
My additional affidavit at page 5. My official affidavit filed on 11 April 2023.
Yes.
That at paragraph 2 of my additional affidavit, that while supplementing the pleadings made in the writ petition, it will be worthwhile to note that the contents of order number so-and-so, Annexure 9, page 39 and 40 of the writ petition, contains a reference of the letter number so-and-so dated 27 August 2007 from the concerned department. A perusal of the said letter dated 27/8/2007 will show that a copy of the same was marked to the Finance Department, Government of Meghalaya, by its seal number 10 thereof, and the conditions of regularization as finally adopted by the Government of Meghalaya for implementation inter alia contains the following as condition number 2. The period of 3F appointment / ad hoc appointment of each incumbent would be taken to consideration for the purpose of leave, pay, increment, pension, etc. I have highlighted pension, Your Lordship.
Yes.
However, the impugned order dated 19/2/2021 at Annexure 9 to the writ petition, although speaks of condition as stipulated by the said letter dated so-and-so, conveniently omits the word pension as specified in condition number 2 as quoted above, thus rendering the order dated 19/2/2021 More specifically, condition number 4, which I'm aggrieved here, liable for suitable judicial interference of your lordships. Now, your lordship may have a look at page 5, which is the annexure 13. Annexure 13, and
page 7, where at conditions number 2.
Yes, your lordship. The period of 3 of appointment, ad hoc appointment of each incumbent would be taken into consideration for purpose of leave, pay, increment, pension as per existing provision provided under FR 28A. Now that is clear, your lordship. I come back to my writ petition. That the petitioners, although were para 8 of my writ petition, page 12, that the petitioners, although were finally regularized in their services as junior divisional accountant after more than 10 to 12 years of continuous service, by virtue of condition number 4 engrafted in the aforesaid order dated also, annexure 9, all the petitioners were unilaterally subjected to the new pension scheme named style as New Defined Contribution Pension Scheme 2009. It is apparent on the face of the record that at no point of time petitioners were ever given any option to either adopt or not to adopt the aforesaid New Defined Contribution Pension Scheme 2009. That at this point it is relevant to state that by virtue of government policy number so and so dated 20th number 1978, issued by the Secretary to the Government of Meghalaya in the Personal Administrative Reforms B Department, I quote your lordship, it is clarified that a period of continuous officiating appointment under Regulation 3F or an ad hoc appointment of government servants will also count toward leave, increment, pension, etc. on their appointment having been regularized on the recommendation of Meghalaya Public Service Commission Selection Committee. Now, this is my case, your lordship, that I am entitled to pension also apart from the increment, leave, etc. etc. Paragraph 10, that it is clear without any ambiguity that on regularization of their services on recommendation of MPSC, the petitioners are entitled to be counted for the purpose of leave, increment and pension, etc. with effect from the date of their joining, wherefrom their continuous officiating appointment under Regulation 3F started. Hence, the New Defined Contribution Pension Scheme 2009, which came into force with prospective effect on and from 1/4/2010, cannot be unilaterally enforced on the petitioners inasmuch as a set scheme of 2009 can be made applicable to new entrants joining service on a regular basis after 1/4/2010 and or whose services will be regularized against regular posts on or after 1/4/2010. It is stated that the government policy contained in the official letter annexure 10, lordship, which is 20th 11/1978, having held the field and guaranteed the rights of the petitioners to be regularized in their services with effect from the date of their continuous officiating appointment for the purpose of counting the pensions, etc. The government cannot now turn around and subject the petitioners unilaterally under the New Defined Contribution Pension Scheme of 2009, in violation of the prospective nature of the scheme itself. That it is further stated that the formal date given to the instrument or letters conveying the factum of regularization of the service of the petitioners cannot override the government policy contained in the aforesaid letter dated 20th 11/1978, Annexure 10. The act of the process of regularization by the government is not at the hands of the petitioners. Your lordship will have to note this, that the act of the process of regularization by the government is not at the hands of the petitioners, and their regularization by virtue of the delayed government decision as contained in letter dated 19/2/2021, Annexure 9, is an act solely attributable at the hands of the government, for which no contributory failure can be attributed to the petitioners so as to take away the right of their services being counted with effect from the date of joining for the entire period of their continuous officiating appointment under Regulation 3F of the MPSC Regulation 1972. Hence, any interpretation to wash off the benefit of the entire period of continuous officiating appointment of the petitioners for the same being counted toward their pension will be ipso facto arbitrary and liable to be struck down on judicial scrutiny. that the petitioners on their entry in service and consequent regularization on getting increments, etc., where and are entitled to be regulated by the terms of Meghalaya Civil Service Pension Rules 1983. The said rules of 1983 is delegated legislation enacted as per the constitutional mandate of the proviso to Article 309 of the Constitution of India, and the same cannot be superseded in any manner by force of the new defined contribution pension scheme 2009, which is at best an executive act of the government. Hence, the petitioner's right accrued under the pension rules of 1983 will survive above the provisions of the new defined contribution pension scheme 2009. More so, by virtue of the government policy contained in letter number so-and-so, dated 20th November 1978, it is reiterated that the policy decision of the government dated 20th November 1978 and the rights flowing therefrom to the petitioner cannot be infringed by the condition number 4 contained in the letter number so-and-so dated 19 February 2021, which is at Annexure 9. That in spite of the above, the respondents are and have been resorting to coercive methods to force the petitioners to forego their rights under the existing pension scheme, which also includes the General Provident Fund benefits. The authorities have since stopped deducting the General Provident Fund contribution from the monthly salary of the petitioners, and also for long is abstaining from deducting at source the GPF contribution of the petitioners from the monthly salaries. On its part, the government has also stopped making contribution to the GPF of the petitioners. That when the petitioners refuse to budge down and submit details to the respective authorities in terms of the various forms framed under the new defined contribution pension scheme 2009, the respective treasuries held back the disbursement of the monthly salary bills of the petitioners, so and so. On being questioned, the respective controlling authorities under whose establishment the petitioners are posted and discharging their services revealed the existence of a notification number so and so dated 30th August 2019. This is at Annexure 12, Annexure 11, Your Lordship, which mandates that in the event of the employees not submitting PPAN and PRAN forms in compliance of the new defined contribution scheme of 2009, their salaries will be held back. At this stage, Your Lordship, I'd like to mention that by virtue of this Honorable Court's order, we have been getting their salaries. There was no stoppage anymore. That accordingly, the petitioners are at times being made to discharge their duties as government servant without being paid their money salary, which amounts to violation of mandates of so and so. Paragraph 16. That fundamental rights of equal treatment of and under law of equal protection and fair treatment as government employees, as well as the right to livelihood as guaranteed under Article so and so, are being severely infringed and the arbitrary legal actions of the respondents. Right, pension is not a bounty, Your Lordship. That is at paragraph 17. Now,
no, the case is only that you appointed before that, then you should have this Meghalaya Civil Service pension was applied to you.
Yes, Your Honor.
Because your regularized will effect from 2000 and before 2010, before the new defined pension scheme came. Yes, Mr. Sengupta.
I've got some
authorities.
I've got a lot of authorities in this regard, Your Lordship, of the Apex Court, and the latest one it says that.
About the DF Nakara case.
Then there's a beautiful judgment of the Madras High Court also on the same subject matter. They were appointed prior to the coming to scheme and approval after the coming of the scheme. The High Court at that point says that they are to get the old benefit under the old pension scheme.
Let's see that.
The Supreme Court also has.
No, come, you bring it to the authorities. You give a list of books?
I've given a list of books, Your Lordship.
Didn't give, not given, Mr.
Sorry? Oh, true oversight, Your Lordship.
My Lord, I don't have any case law to support that they will be entitled to the old pension scheme or not, my Lord. I don't have any case law on this particular issue, my Lord, because it's a policy decision and the government all of a sudden, even to my own understanding also, I was not so clear, saying that this might have been applicable only for the new entrants. Only subsequently after the filing of this case, I came to know that the government wants to implement it even for those who are not regularized.
Why?
My lord, this is coming up for the first time, my lord, that
Where's the policy
those
decision?
cases which are pending for regularization, they will be covered under the new pension scheme. Because new pension scheme, it is your own contribution, you are creating your own pension fund.
No, see, regularization in this case is different. It's not these other cases. This case is different in the sense that they've been working now, they've been regularized, and as per the application of the memorandum by which they were regularized, that says that for pension and all other benefits will be considered on that date. Correct.
Correct.
So that's also now that how has that policy decision removed all those? Has it referred to those letters also specifically to their appointment? They have acquired a vested right.
They have acquired a vested right, but the government at the stage has come to a decision that.
Where's the policy decision?
The policy decision has not been provided to me.
How? Then why you then we should see before the hearing started?
My lord, our limited instructions and
You bring problems. I'll make the officer come here on the next day.
Yes, my lord, because they will be in a better position to explain.
Oh, that's very correct. You'll bring the file. You bring the instructions.
The extracts of the file we have already brought in, my lord, because as per the last direction, my lord has directed me to produce relevant document. The file was coming into huge volumes, and from there, the important documents has been sorted out by my officer.
What did he say?
My lord?
Where's the policy decision?
My lord, here...
Specifically to their case.
My lord, here I did not see any particular policy decision. It is only the manner in which it has come to this conclusion, my lord.
It was the joint director on his own who had put up the file and did this.
Who's director of Treasury?
Of the finance. It was at his level, that joint secretary, I think, joint secretary. We were aware of that, and it was brought to the notice higher ups. He said, what to do? We have by this. Your Lordship was referring to this judgment of Ranjit Haraj.
No.
This is a 2022 judgment, Your Lordship.
You didn't get the list of books. What will you do?
By through oversight, Your Lordship, we can pause for today, and my colleague can, if in case they have something.
Pause for today. This court will be not here from it. We'll be here only for 4 days next week.
Pardon, Your Lordship?
Only for 4 more. It will be there for 4 days next week. After that, this court won't be available for some time.
So within that time, within any days, even by tomorrow also, if my colleague. I'm already.
There's no urgency right now, Mr. Kinta, because these people still have long years of service. If the matter is very urgent, someone's not getting the pay and they're getting paid now, then you will take it after 3 weeks. You just bring the proper authorities.
Much.
After a matter of hearing at some length, it appears that some instructions have been received by Mrs. Sengupta, who will place the same the next date.
My lord?
It appears that some instructions have been received, Mrs. Sengupta, who will place it on the next date. Correct? Will place the ones you received.
At the time of hearing, I can.
At time of hearing is something. The next date at time of hearing.
They have been flag-marked and given.
Yes, this matter after 3 weeks.
The volumes were so huge, my lord. I did not find.
You have our sympathies.
Lordship, just my apology. Lordship was referring to Natharaj judgment.
You see, there's regarding retrospect. I forgot the judgment. It's with regard to the applicability of schemes. You know, because anyway, not material. Yes.